Tuesday afternoon, February 18th, and we are going to spend the next bit on H105, which proposes to expand the youth substance awareness safety program in different ways. And we're going to start with a walkthrough on the bill. Thank you for being here, Ben.
You look familiar for some reason.
Ben,
just bear with me as I get logged in.
What number is that?
105. Did I not mention H105?
I might have.
But
Hey, good afternoon, not morning anymore. For the record, Ben Novogrodsky from the Office of Legislative Counsel. For the committee is H105, which is entitled An Act Relating to Expanding the Youth Substance Awareness Safety Program. This bill does a few things. So first, it proposes to expand the Youth Substance Awareness Safety Program, which is commonly known as YSASP, by lowering the minimum age of eligible individuals to 10 years of age from the current limit of 16, and to include violations for youth to engage in impaired driving with a minimum 0.02 blood alcohol concentration. And this does a couple other technical changes. It enhances some confidentiality and public records protections for those that are engaged in the YSAS program. There are restricted driver's licenses that can be obtained, and then there will be an automatic reinstatement of their operator's permit if there's a successful completion of the RDL program. So there are some issues to discuss. But at the outset, I think it's probably good to go through sort of a primer on what YSASP is. So YSASP provides an alternative to the civil court process for youth who violate Vermont's underage alcohol and marijuana laws. YSASP helps young people to understand the impact on themselves and others of using substances and to lower their risk of future use, while connecting those identified as using at high risk levels to professional substance use clinicians. So that's sort of the overarching purpose. The way that this works is that individuals who are referred by law enforcement to YSASP, so their YSASP is run by court diversion, so it's really a diversion referral with the expectation that they enroll in YSASP itself. And those who choose to participate, so it's all voluntary, and are successful, avoid having their driver's license suspended. So that's really the incentive, as opposed to going through the court process, which we've discussed already on a couple other bills. There's that civil license suspension process. So it could theoretically avoid it if you're successful in YSASP. So participants meet with staff for an initial screening and then sort of an educational discussion. Some youth may need to meet with a substance abuse counselor for an assessment and then follow through with any recommendations that are provided. Again, participation is voluntary, and there is a fee, which is capped in this bill. And if an individual chooses not to participate in the program or fails to complete it, a ticket is issued and sent to the individual and the Vermont Judicial Bureau. The Bureau can levy a fine and informs the DMV, which can then suspend the individual's driver's license. And there's also sort of an appeal procedure as well within the Judicial Bureau if they contest the case for whatever reason. This bill is really addressed at remedying two issues as they have been explained to me. One is for those that possess alcohol, and they're under 16. In some areas of the state, some law enforcement officers prepare delinquency petitions, which we've discussed about how this sort of goes in the context of other bills. But in other areas, there's confusion, and officers sometimes issue a YSASP notice of violation. And then when YSASP staff inform them that the violation is a delinquency, the officer may not have also written the delinquency petition. So there's sometimes a gap in enforcement depending on where you are in the state. So in that case, the youth is provided with no intervention and experiences no real accountability. This proposal aims to ensure a simpler system for law enforcement as well as those who work for the state in these programs, and ensure a timely and appropriate response to youth possession of substances and their use thereof. The second problem is underage drinking, essentially. So 0.02 civil violations. So youth who are stopped for driving under the influence will typically receive both a DUI 0.02 ticket, which is outlined in 23 VSA section 2016, which is actually being repealed in this bill and rolled into the statute before you, and a notice of violation for possession of alcohol. These violations require different responses under the law, and on the youth's part, and can lead to different penalties. Oftentimes, there's confusion about which track they're on and which requirements can sort of lead to disposition of one case or the other. And the paperwork can be confusing. And the real issue is that a lot of times people think that they're completing YSAS, or that their completion of YSAS will also satisfy the DUI 0.02 violation. As a result, there's often surprise at the end of this process to learn that the driver's license is also suspended and that they're also required to complete IDRP. In the interim, they continue to drive without intervention that would have been imposed by IDRP, and they could accumulate license suspension violations. So that sort of bifurcated response to both underage alcohol possession and underage impaired driving has public safety implications and accountability and rehabilitative issues as well. So this essentially aims to streamline it, make it less confusing, and more appropriate and proportionate in its response. So that's the general overview, and I'll get into the details of the bill unless there are any questions at the outset.
Good. Go ahead.
So this does alcohol, it does cannabis, it does everything, right?
The YSAS program, yes.
So my question is, when you got where is it, 0.02?
Mm-hmm.
Haven't we been over this before where, like cough syrup, like that has alcohol in it, right? Or there's some sort of there's some sort of over the counter, or has that now been eliminated to where a kid or somebody underage or somebody actually overage, if they're taking the cough syrup too, that could push them over the legal limit? Is that?
I don't know.
Anyone want to help me?
Well, you can ask witnesses. We have other witnesses.
All right. I'll wait my
Use
turn.
mouthwash as an example, it's got alcohol.
Okay, thanks. Right? So I am going down the right road. Okay, I'll wait for a witness.
0.02 or more, or what about between 0.02 and 0.08?
So we'll get into the details
Okay.
of the bill, and we'll kind of get into that. But I'll keep those questions in mind going forward. So section 1 of the bill amends 7 VSA 656. And so you'll see right at the outset on line 3, striking that a person 16 years of age or older down to 10 years of age or older, but under 21 years of age, who misrepresents, procures, possesses, or consumes alcoholic beverages. That's what the basis of the violation was. So it was just, did you lie about your age? Did you possess? Did you consume alcohol? Here's the violation for that behavior. What we're also adding is impaired driving and the civil violations associated with that penalty to this statute. You'll see there are some technical changes as far as reader assistance headings to clarify some things. You'll see on line 8, again, the change from 16 down to 10. But then at the top of page 3, on lines 3 through 5.
Chair,
Okay.
I have a question for this. With the 10, So I'm just trying to think how this ties into the other bill that we're doing H2 with, we're raising the bottom. Do those connect at all? Where we're saying in H2 that it would be, what is it, 12? Would be the starting point. Would we, right now, that's not obviously law. We haven't passed that yet, but would we need to align that, or is this totally different, separate?
I'm not that familiar with H2, so it's hard for me to
It
say.
raises the delinquency age from 10 to 12.
I mean, what this is doing is kind of taking that delinquency process and turning it into this civil YSAS process.
Okay.
So, but if they fail to complete that YSAS process, then there's the court process that could play out.
So this probably does have to.
So I'm just gonna flag it, that we want to align it.
Okay,
But that bill hasn't even made it out of committee yet, so.
I'll be sure to talk to Eric to get some more details on it. But looking at page 3, lines 3 through 5, this is really what rolls in that big violation of impaired driving. So when someone attempts to operate, or is in actual physical control on a highway of a vehicle when the person's blood alcohol concentration is 0.02 or more. So that was the policy decision that was implemented when the other statute was passed. That provision has just rolled in to this statute now to be included in the YSAS process as a violation.
Page 3, line 3 through 5, that's a civil penalty.
Yes.
So that's for somebody from 10 to 21 years old.
In this bill, yes.
So they can drive impaired and get a civil penalty. But if I drive impaired, I get a criminal penalty.
Well, there is the criminal violation as well that exists under 23's VSA 1201.
So it could be either or.
Well, it's a civil track, which is the license suspension and the civil penalties associated with it, as opposed to the criminal track, which can have other consequences. So we're just in the civil realm right now.
Are you going to explain how it can be criminal?
Well, you could get charged criminally, or you can get a notice of violation civilly. Oftentimes you receive both.
What if I was above 08? Can I be charged civilly?
Yeah, that's what the section 1205, that's the license suspension discussions that we've had on the other bills.
I'm just looking for equality, I guess.
Right. So what this is really doing, this changes the civil process, doesn't change the criminal process. What this is doing is just rolling in, basically giving those who have driven drunk for 0.02 the same opportunity at YSAS as those that have possessed, consumed, or misrepresented their age.
Again, just for clarification, somebody above 21 years old would have the same opportunities for civil charges.
Well, it's the civil suspension process under 1205 that applies to both.
If an adult receives a DUI, they get a criminal and a civil penalty.
Or both,
Right.
but under 21, potentially civil only.
Well, but you could still be charged as well. What this is doing is changing the civil procedure so that, because the confusion that resulted from, okay, well, you have this YSASP enrollment that you can participate in and all the requirements associated with that, but there's also the civil suspension procedure and all the requirements associated with that. This is trying to roll those provisions into the same statute so that they have the opportunity to complete YSAS without sort of the competing and confusing requirements under two different sets of laws. It's giving them the opportunity to complete YSAS first, and if they don't, then the civil penalties can go into effect. Does that make sense?
This is my Monday.
Yeah.
And, oh, it's confusing.
Right.
And
It's not
I
straightforward.
think, and
No, it's not.
all along, there's the criminal side to things, which is complete.
Right, and we're not talking about the criminal side of things on this. We're just talking about the civil process.
Okay, in that case, I won't even ask. Yeah, we're not, theoretically though, you could be charged with like an impaired drive, like impaired to the slightest degree criminal charge with this civil charge, even if you were under 21, which I think was kind of what Tom.
Theoretically, it's possible, yes.
Yeah. Great.
Okay.
Okay. You have a question?
Would this be handled under the 240 form side? Or would it go?
Remind me on 240 form.
Well, that's the civil suspension side of the DUI criminal process.
Right, so could implicate the 240 form. Any other questions? Yet, another will be. So again, so this just provides a new basis of a civil violation for impaired driving for 0.02 or more. So that's what D on 3 through 5, lines 3 through 5 does. And then you'll see again, what subdivision 2 does is sort of separates those misrepresenting age, possession, or consumption offenses are under subdivision 2. And then subdivision 3 is the addition of those new impaired driving provisions that were rolled in from the other statute. So you'll see what this does now is that someone who violates the impaired driving portion of this commits a civil violation and shall be referred to diversion for the purpose of enrolling in YSASP. Someone that fails to complete the program successfully could be subject to the following. So this is where those civil penalties could kick in if they don't complete YSASP. So for the first offense, it's a civil penalty of $300 and a 6 months suspension as long as they comply with the proper requirements. For a second or subsequent offense, civil penalty of $600, a suspension of 1 year, or until the person reaches 21 years of age, whichever is longer, and they comply with the requirements.
So just a question, is this current language just elsewhere that's
Yes.
moving to here? So this is essentially current law, but we're putting it in a new place.
Correct.
Okay, just wanted
So
to.
this is rolling in 23 VSA 1216 into 7 VSA 656.
Say it again, 23 VSA, which one?
1216,
Okay, 1216.
which is going to subsequently be repealed if this were to pass.
Right, okay, all right, so go ahead, we're, Tom.
So if they were under 21, but it was a commercial motor vehicle and it was a .04, would that change the situation as a or okay problems with the statute?
It would fall under the .04 violation of 1201 for the criminal violation.
Still work.
But if they're under- But if they're 21 or under 21, this is the civil process that they would be subjected to.
I don't remember hearing that was.
No.
In the items that it addresses in the beginning. I guess it will have to.
Well, let me I'll double check on that for you, just about the commercial side of it. Because I'm not 100% confident, so I'll get back to you on that. Okay. And then finally, you'll see under subdivision 3, there's also, you could be subject to recall of your provisional license. So if you have a learner's permit, it could be pulled basically. Subdivision 4, and again, this is all current language, that if a police officer has reasonable grounds to believe that a person has violated that impaired driving portion, they can request that you submit to a road preliminary screening device, not an evidentiary one, the roadside PBT test. As long as it's approved by the commissioner, and a refusal should be considered a violation of that. However, notwithstanding any provisions in 23-1202, the implied consent statute that Representative Goodnow referenced in his floor speech today, and 1203, the results of the test can be admissible in a proceeding. There's no statutory right to counsel, and the reason why is that these again are civil proceedings, they're not criminal. So there's a different calculus as far as when your rights are called into question and the stakes that are at play. Again, proceeding on, subdivision 5, in a proceeding, if at any time within 2 hours after operating, with a BAC of 0.02 or more, it creates a rebuttable presumption that they had that BAC. So again, we're kind of getting into the evidentiary side of things about what could be used in a civil proceeding if they didn't complete the YSAS program. So again, that's the big kind of contingency. If you don't complete YSAS, here's the process, and it's already in existence in 23/12/16.
Just moved here.
Just moved here.
A process question, will, when someone is completing YSAS or is enrolled in YSAS, are they, they're able to drive?
I'll defer to diversion on that one.
Okay.
Yeah. My understanding is that their license isn't suspended as long as they complete it. But again, I'll defer to the practitioners. So going into subdivision 6, no points are assessed for a violation. Subdivision 7 is basically you have to go into the alcohol and driving program run by the Department of Health. And it will consider your treatment needs for those under 21. A new addition is on 16 and line 16 and 17 there, that last sentence, which caps the program fees for those under 21 to not exceed $100. So that is a new addition. Subdivision 8.
So there's no cap right now?
Correct.
Yeah,
Can I just, this is the IDRP program that we took. I just want to connect the dots on it, that we took the testimony on the IDR program, like with the high cost associated with that.
Yes. So if that bill were to pass, it may change this.
Interconnected.
Yeah.
Okay.
so does this $100 cap change what's current law as far as what the cap is right now?
There is no cap right now, so it does change current law.
Okay, so do we know what kind of impact going to $100 relative to what they're actually charging?
We do not.
No.
Or at least I do not.
So this one would have to go to.
If we included that.
Or Ways and Means, if we include that sentence.
Mhm.
It's like sentence.
That's what I did.
So,
So to answer some of the other questions, subdivision 8 says that, again, a charge of violating this section does not bar prosecution of any crime, including one under 1201, which would be 0.08, the commercial drivers, 0.02, or impaired to the slightest degree. Sometimes I refresh my memory as I go as well. Again, suspensions that are imposed under the possession statute or any comparable statute of any other, any suspension will run concurrently with any suspension imposed under 1205, which is the civil suspension statute, 1206 or 1208 or any comparable ones. Or with any suspension resulting in a conviction for a violation of 23 VSA 1091, which is negligent operation from the same incident, and the person can receive credit for the elapsed period of suspension. So really elaborate way of saying, if you're suspended under this, it runs concurrently with any suspensions that may be imposed under these other statutes. Again, during the suspension issued under the relevant provision, you can operate a motor vehicle if issued an ignition, interlock, restricted driver's license, or certificate in accordance with the applicable law. But again, that's if you don't complete YSASP and you're subject to the civil penalties. And again, this is some new language here for I and little I and little double I. Someone that's subject to the penalties and elects to operate with an RDL shall be automatically reinstated if the person operates it for a period of 180 days, which is 6 months, in addition to any extension of the period arising from a violation of that. So essentially the way that that statute works is that, so the RDL, for those that don't know, is you have the ignition interlock device, you have to blow into it in order to operate your vehicle if you're subject to these penalties. If I forget the exact number, but I think if you get maybe 3 or more like readings that said, you were impaired, that can lead to an extension of the time. So it would extend the 180 days by a certain period of time. And there's a whole essentially regime of statutes that do that for the extension. So you have to remain sober to operate the vehicle. Therefore, if you do that, automatic reinstatement will occur at the successful completion of that period of the RDL license.
So which lines are new language from current law?
It would be the shall be automatically reinstated.
Well,
Line 12, and then again on line 18. And so line 18 just references that continued sort of enhanced penalty of if you had a year suspension or until you reach 21, whichever is longer. Again, automatic reinstatement if you've complied with the requirements of the RDL license. You'll see here on page 7 a new addition as well, that someone shall not be cited for more than one violation of subdivision A arising from the same incident. So basically what that's saying is that the prosecutor, the law enforcement officer has to pick what they're going to charge with. You can't be charged with consumption, impairment, possession. They have to choose. The rest are just sort of contextual additions, so that if anybody is interested in learning how the whole process works, they can read through it, but there aren't any other changes. You'll see scrolling down on page 11, line 8. This is really a technical correction that came out of Act 180 of last year. This is just changing the cross-reference to the juvenile and adult diversion statutes to any law to the contrary, because there are multiple laws that may be implicated. So it's just making sure that the confidentiality provisions of diversion go into effect in spite of anything else that may say otherwise in this circumstance. And then you'll see in subsection H, those enhanced confidentiality and public records exemption that I mentioned previously. Right now, the requirement is that the Commissioner of Motor Vehicles maintains a record of all of the adjudications that are partitioned from other adjudications. And the identity of the person in that registry shall only be revealed to a law enforcement officer when determining whether that person has previously violated the section, which is current law, but a new addition, which is to an insurance company or its third-party contractor, only for the purposes of recording a license suspension issued pursuant to the relevant provision. So basically, if they need to increase their premiums because you have a license suspension, they have the information to know and do that. And then you'll see the addition of subdivision 2A and B that states that all the information is held strictly confidential and not released without prior consent, and that any records or information produced or acquired pursuant to a suspension is exempt from the Public Records Act. You'll see in section 2, 7 VSA 657A and 23 VSA 1216 are repealed because those statutes have been rolled into this one. And that in section 3 states the act will take effect on July 1st of this year.
Implied consent.
so questions for Ben about the draft? Ken?
I'm not really sure this is a question for Ben, but I'm thinking about the victims, like everything that is like hidden or concealed, whatever the word is I'm trying to use, which I'm not good at. But is that fair to the victims to have everything, like the person that commits this crime is?
So again, this is the civil side. So we're not talking about the criminal penalties associated with it. This is just the license suspension information that would be confidential and exempt from public records, unless you're a law enforcement officer who's trying to investigate the crime or the insurance company. So this doesn't talk about the criminal side of things. This is just the civil license suspension information.
So the insurance company would have access to it too?
It could be disclosed to them, yeah.
It could be.
Yeah. Mhm.
Okay. Thank you.
So I have a, go ahead, Ian. I'm sure your question's better question.
Yeah, not at all. Is the, so if this were to pass, if someone, between the ages of 12 probably and 21 were to have, a 0.02 or above, is there discretion for a prosecutor to choose to go through just the normal civil suspension process, or do they have to go through this?
They would have to go through
They would
that.
have to. Okay. Wow.
Isn't it, that's on page 3, line 19 to 21, right?
Yes.
Yeah.
I
But,
just wanted to clarify.
but where the discretion lies is in the selection of which violation. But once they issue the notice of violation, then it's YSAS process for everybody.
Yeah.
If you fail to complete it, civil process.
Yeah. Yeah. Yeah.
Ian, what do you mean by wow?
Yeah, I was gonna ask that same thing.
I'm not gonna,
If
I am
wow
not,
is all you
I'm
want,
not, I'm not a witness, so I'm not testifying.
Oh, that's fine, that's why I said.
So we can have that during discussion.
Yeah.
I was told by Jill, I have to talk to everybody about witnesses at some point. We'll do that at some point. My question, page
That's how
12,
Page 12.
line 7. What's the difference between strictly confidential and confidential?
That's a good question. I think
It's
it's
like, we really mean it this time?
Yeah, it's like.
essentially, yeah,
We use that terminology elsewhere?
yeah, we do. But I can't say if it's consistently used or not, but strictly confidential is used in our statutes.
Yeah, I know what the difference is. All right, thank you, Kat. Thank you for that, Ben. All right, so Willa, let's hear from Willa and tell us why these changes are so important. It's for Ken Witz.
Good
Welcome back.
Thank you. Good afternoon, Willa Farrell, Court Diversion and Pretrial Services, Attorney General's Office. I thought I'd start sort of broad brush and then go into a little bit more detail. So I think the issues that I hear from programs that I brought to Representative Dolan and then in talking with Ben, we're trying to address further the goal of making sure that when youth, in both contexts of this bill, have alcohol, I would also add cannabis, or drive at a low level, 0.02, that they have a very fast response, that we don't, as society, sit back and wait for processes to happen, that we do a timely intervention. And that is really the goal. So whether we hit it on all the mark here, that remains to be seen. And to do that timely response, I think that there should be a system that's clear and understandable to youth and to parents who are often part of these discussions, and make it fairly simple for law enforcement, prosecutors, and the program staff who are doing the work. And then also to create some equity for kids who are under 16 and over 16 who may be at the same party. I'm not talking about the DUI piece now, just like possessions. So those were the overarching goals. I wanted to first talk about the possession by youth under age 16. So right now it's a delinquency. And as Ben discussed, the idea here is to change that from a delinquency to a civil violation, and to follow the same process as if you are 17 through age 20 and you are found to have alcohol, consumed it, or have it in your possession. So right now, what happens is law enforcement are to write out a delinquency petition. Sometimes that happens, sometimes it doesn't, for various perfectly understandable reasons. In some counties, those delinquency petitions are automatically referred to diversion. Some counties, they aren't. In some counties, law enforcement are told, don't write up the delinquency petition, just refer this pre-charge. So there's an array of events happening about how law enforcement deal with these violations. And so the idea here is, in the same as if you were 17, if you're 15, you would be given this notice by law enforcement that says you have 2 weeks to contact this program. In the meantime, they're also going to be contacting you. And you're going to meet with staff, do a screening, talk about why you were drinking or smoking pot that day. And then if we're concerned about you based on this evidence-based screening tool, we're going to ask you to see a clinician and follow their recommendations. And if you complete the program, then you're good to go. But if you don't complete the program, you never contact us, or you fail the program, the ticket is issued, just like a speeding ticket. And then you get the consequences of a 30-day license suspension and $300 fine. And those two pieces are motivators, frankly, for kids to participate in this program and meet, which in some ways can be a pain for them. They have to meet with somebody and talk about what they did and if they like how it affected their family, all that sort of restorative process. The idea here is with that law enforcement providing the youth that piece of paper, and then I won't go into all the mechanics, but it's very paperwork cumbersome. The officer gives the ticket to the program, and then if the person fails, that ticket gets issued and goes to the Judicial Bureau. If they're successful, it's voided, but it's fast. So you're given the ticket, you're giving you the piece of paper, and you're said, contact the program. The program hears from the law enforcement officer. I gave Karen the ticket, the paper, and then the program reaches out, says, you got to come in. So that's the first section, just that change of age. And I agree, if you change the provision to 12, it should mirror that. I will say that getting anybody under 15 is really rare. I mean, last year, there were about 850 youth who went through this program for possession of either alcohol or cannabis. About 70% of them were between 18 and 20 years of age, and 30 were 16 to 17 years of age. So that's who most of the people we're working with. If you're under 18, then your parents have to be informed.
Yeah, that's a good question. I think I would know this because I introduced it, but I don't know all these details with it. So just to clarify the piece around equity of what this is doing. So you're giving that example of the 15-year-old getting that ticket from the officer and the officer also sending it to the program.
Yes.
So one piece is currently under 16 that don't have access to that opportunity.
Correct.
So this would be addressing it.
Yes.
And then the other one is that system isn't set up in every county the same way. That you would get this and be like, you need to contact the program within 2 weeks.
Right.
It's different in each county, and this is standardizing that.
Yes. And I think also the equity piece I was thinking of was, as you know, teenagers mix and often are at parties, and you may have a 15-year-old, a 16-year-old, a 17-year-old at the same party. And so the officer has to give the 17-year-old the notice of violation and the 16 and 15-year-old a delinquency petition. So they may be siblings or they may be neighbors, and they're like, you got that? I got this. And the parents like, I have to do this. I have to do that. So it's just simply confusing for people. In an ideal world, and I would say in most cases, that delinquency petition leads to referral to diversion, and you would probably, as a youth, have a very similar experience as your 17-year-old peer, but that's not going to happen for a few months. And last year, there were only 30 delinquency referrals. I mean, the vast majority of youth with alcohol or cannabis are older, at least that we're seeing, you know, that and law enforcement is seeing. So that's that piece.
Yeah, go ahead.
Can I just add something to that? That seems extremely low. The first thing that comes to my mind is law enforcement even reporting it. And I'm not accusing law enforcement of not doing their job. It's just like, is it so minor compared to what's, well, that's lack of better words, minor, but it's like, there's so many other bigger things that's going on that it's just not being reported.
I mean, I think obviously you're going to hear from law enforcement. I think probably these numbers don't reflect the extent of substance use by young people.
Yeah.
I think
Okay,
that's,
yeah.
I mean, my, like public health, I'm sure there's public health data out there that would probably, there's the youth risk behavior, YRBS, that survey that's done in schools where kids report their use.
Yeah.
And I bet that percentage is higher than these numbers as a percentage.
Thank you for putting in that much better eloquently words than I did.
And thank you. The second portion of the bill, I think, is more challenging, and the goal was the same one. Let's have a system that expedited young people getting an intervention when they drink at a low level. So I'm still learning more about DUI, but really where we're talking about so if you're over 21, legally, you may drive with a blood alcohol content of like 0.04 or something, you know, it's only up at 0.08 that it's a violation for an adult, except for the expression.
Impaired to the slightest degree.
Compared to the slightest degree, but like if we're just talking EAC numbers, right? It's my understanding of the law.
Okay, go ahead.
I just got lost.
So the provision in this bill we're talking about is when somebody's blood alcohol content is 0.02 and more and under 21, not whether they're 0.08. Is that clear?
But we're going up to age,
20.
oh, that's right, because drinking is no longer 18 back in the day when it was.
Just aged yourself.
Maybe a better way to put it is if you're over 21, you can't get a 0.02 ticket.
Well, if you're 21 and older.
Right, 21, if you're 21 and older, you would not get a 0.02 ticket, but you could be charged being impaired to the slightest degree.
On a 0.02?
Unless you're driving a commercial vehicle.
See, there's the details. We'll let
That's, okay, but that's the only way.
Pardon me? Wait, I don't know if you want me to answer for that.
Yeah, so we're gonna have you up next, so hold that question for the lieutenant.
So I'm no expert and I don't want to muddy the waters. I'll just try to speak to
Oh,
like what the goal was. So currently with the 0.02 ticket, and you'll hear from two of my colleagues who can give you more examples. If you get one of these 0.02 tickets, the consequence, there's no fine in current law, but there's a surcharge of $45. So a person may get one of these tickets and think, oh, $45, that's not bad. I'll just plead guilty, put in my check, and off it goes to the Judiciary Bureau and you're adjudicated. And then the consequence is your license is suspended. People don't often understand that their license is suspended and they keep driving and they don't do IDRP because they don't realize they have to do it to get their license back. And that's the gap. From a public safety perspective, in my opinion, is there are some people, there are not a lot of them. There were only 40 who went through the Judicial Bureau with this ticket last year, but only takes one, as we all know. I think that group of people, young people who have a small amount of alcohol and they're driving, we should be intervening and making sure they get intervention, accountability and intervention as quickly as possible. So this was the attempt to do that, was to say to the young person, go to this program, and if you complete it, you don't have the same consequences. Representative Arsenault's question, and I do think this is an important piece that I had not fully processed, is like the way this is drafted, there would be no suspension for somebody who went through the program successfully. And I think that's an important policy issue to consider. There is, these are low-risk youth, and it's a first time only, but that is an important piece that I think I, for one, and others probably think more about. And I'll just reiterate to the point of just really trying to make sure we shorten the time between the time somebody drives and what their accountability is in their intervention. So I think that's really the gist of my point. I think I would just stop there.
Any questions? So I'll ask one, as far as what is the going rate? Because there's that, on page 5, the cap of $100.
It's, for IDRP, it's $400.
Any other questions? Yeah, yeah.
So hearing kind of like the goal
Yes.
for youth who are below low BAC.
Yes.
And the way I read it, the proposed language right now, this would be applicable to anyone between the ages of 10, currently 12, probably moving up to 20
Mhm.
that blew any BAC above
Yeah.
0.02.
I noted that when Ben was going through, and I think that's because that's current law. And so I think you can now get a ticket for 0.02 regardless, like as long as it's above 0.02. There's no cap. It's not like
Yeah.
there are no parameters around that. And I had missed that. My thinking was more low level. But if you are at 0.08 or impaired such that an officer is really concerned about your behavior, and then that's where I think an officer would be using the criminal, or if you're young, a delinquency, but under that DUI statutes.
Okay. Thank you.
Other questions? I don't see any. So we will move on to Lieutenant Ravelin. Did I pronounce?
Yes.
Thank you for being here.
Thank you for having me. Good afternoon. I'm Lieutenant Paul Ravel of the Vermont State Police. I am the executive officer of the Special Operations Unit, which also includes the Traffic Safety Unit. I have to commend Willa. I'm going to give her a Stetson and a uniform when she's done, because she clearly identified some of the issues that law enforcement sees with underage drinking. And I too will use a reference of like a underage drinking party. One comes to mind that I attended, not attended as an attendee, but I went as law enforcement, but it was a group of kids that just graduated high school. Folks let them use the lake house, and there's 80 students there. So we get called there to do excessive noise. And now we have 80 students and 6 law enforcement. So we have to process all those ranges of ages. So some are 17, some are 18. There's siblings, so some are down at 15. And we have to separate all them out, first by drinkers and non-drinkers. Admittedly, they're all going to get a field PBT, a preliminary breath test, but we just give them the opportunity to be truthful up front. Let's separate who's been drinking, who hasn't. And then we separate them again by age. And if we have someone that's 15 and they get the juvenile petition, that has to be signed by a parent, so we have to call a parent. Now, Some of these kids are out of state, so we have to wait for an adult to come up from Massachusetts to get the petition. And I mean, this thing gets really, really convoluted when we start talking about different ages. So when I see this bill come forward saying that we're going to streamline the whole thing and create a system as if everyone was like over 16, but they're all getting the same attention, immediately law enforcement's like, yes, okay, it's streamlining some of our attention to what we have to do on these cases. So like Will had testified earlier, it's very intensive as far as paperwork and follow-up for the law enforcement officers. So currently, if someone's 16 for simplicity and they blow an O2 at an underage drinking party, we give them their diversion paperwork, say within 2 weeks, you have to, we circle the county that they're in, you have to contact this board within 15 days, tell them that you're in diversion. We then write out a traffic ticket, which would be like you would get if you were speeding, 4 copies, that stays at the barracks. That is held kind of in limbo until they complete the diversion. If they don't complete it, we get notified and then we have to go track that person down and then issue them the ticket then. So it's not over until it's over for law enforcement. It just hangs in limbo. So we have a separate file at the barracks that our administrative assistants put all of these tickets in. And then we have to go through them again and pull them out if they complete it and it gets destroyed, or we serve it if they fail to comply. So some of that stuff is still we'll continue on with this bill, but just having it simple of not having to break it down from how old are you, siblings, cousins, same age, friends. This will be a lot simpler, cleaner for us. There is some inconsistencies, as testified earlier, to different counties and how they're handled. So if I bring in a juvenile petition to someone that's 15 to a state's attorney, they're just going to, certain state's attorneys just say, no, refer that to diversion. So we go to diversion and we're saying, hey, they're telling us this. And diversion's saying, no, you can't do that. You have to do it this way. So it's just back and forth. And it's almost like the case that never ends, right? Until we can finally get the right paperwork to the right students. Meanwhile, it's 3 or 4 days have gone by. And the timeliness of trying to get these folks into the right program so they can understand the significance of driving, of impaired drinking while at a young age, consuming cannabis at a young age, or even driving with that O2 issue at a young age. The sooner the education can get to them and the severity of, if you continue on with this, what it will look like, the fine hanging over their head, the suspended license hanging over their head, just realizing that this is a very serious thing where their privilege to operate could be suspended, or much worse. So they become addicted or they get injured, things like that. Things that we've seen from impaired individuals making poor choices when that first police car pulls in the driveway of an underage drinking party. We've had kids run through the woods, jump into rivers. We've had middle of winter, I was standing in the foyer of a home looking down, and there was 50 pairs of shoes and there's 4 kids in front of me. So the other 46 kids are out in the snow with no shoes on because they're running from the police because of what's going to happen, right? So some of these can be pretty significant when they're making poor decisions because they're impaired, right? So if we can teach them those dangers early on and get to them earlier and quicker, I think this is a beneficial program. So overall, that's why you have the support of DPS, that this is a good change.
Questions, Lieutenant? So I just want to make sure I understand this, and maybe I'm not paying attention well enough, but I just want to just double check. So right now, the person that does the .02, they don't get sent to Yazzie. That's a ticket.
So they'll get diversion paperwork under the, as they're juveniles, they'll get the diversion paperwork and they'll get the O2 ticket.
Right.
And then that they will then say, within 14 days, 15 days, you must contact diversion in your county and let them know that this has occurred. And then from there, diversion will enter them into the program that they need to be in.
So I guess the reason I asked, I'm just looking at the 23 BSA 1216 and versus H105 on page 3, line 19 to 21, and then over to the next page. It's just the language is not as clear unless I'm not in the right place to see that somebody who gets an ticket is sent to the Yazzie program. I mean, it's very clear in 105, but is it? I didn't see where it was so clear in 1216. So yeah, go ahead, Ben.
That's in a different statute.
Oh, okay, all right. So I was looking, all right, so it's not. All right. So it's just that our language in 105 is not just from 23 VSA 1216, but from this other place.
Yeah, it's from I think it's 656A, 657.
Title VII.
And which type? Title. Okay, all right, thanks. That's all. I just was looking at that statute. Yeah.
Will had talked about not the number of cases per minute. With the new way this is gonna be charged, do you see potentially an uptick of what you would be sending per way?
I don't anecdotally, and then the reason for that is to the testimony earlier, most of our violations happen within the 15, 16. We're going to see those anyway. I don't see an influx of us going to a 12-year-old party and seeing a huge increase in what, and quite frankly, our process isn't going to change. We're going to still hand them the paperwork. The difference that would change for us is determining what age they are, and then needing to, if I'm going to hand them the juvenile citation for underage drinking currently, if they're 15 years or younger under Title VII, I'll need to search out a parent to have them file the juvenile citation because a parent needs to sign for that as well. This will allow me to issue them the diversion paperwork, still contact their parent, but the parent could then say, well, my neighbor Jim's coming to get his son. Can he ride home with him? If you're fine with that, we're fine with that because it's sober adults coming. But if I was issuing that child a juvenile citation, that parent would have to then come as well. So it cleans up a little bit with managing a 30-person underage drinking party. The one-offs, if we have an underage driver, that's different because I can handle it one-on-one. But if you're talking 30 or 40 or 100-person party, that becomes super time intensive. If we have one process for all juveniles, that makes it simpler. But it doesn't change really how we would handle it in the sense of I'm still handling the same paperwork. It's just not 3 sheets. It's just the 2 sheets I would have anyway. If that makes sense.
Yep. Angel.
And I wonder if you could comment on the potential policy consideration that I asked about before and that Willa just mentioned about that the if impaired driving is the violation and the person is sent through the YSAS program during that time, as I understand it, their license is not suspended.
Correct. It goes under suspension at the when they do not complete the
Only
program.
if they don't complete it.
Correct. If they reach the level, so we asked earlier about some numbers.
Yep.
So with driving under the influence, there's several different numbers that come to play. 0.08 is permissive inference of you're impaired, like 0.08. If you're driving a school bus, 0.02, you can be arrested for driving under the influence. If you're driving a commercial motor vehicle, 0.04, you can be arrested for that. If your second or subsequent DUI is a 0.16 or more conviction, then if you're driving with a 0.02, no matter who you are, you can be arrested for DUI then. That was like a major DUI or as long as your second or subsequent conviction is greater than 0.160, you can get a 0.02 there as well. So there's a lot of numbers playing in there, but for the sake of juveniles, 0.02 to 0.05, 0.06, those will fall under this program. But if you reach the 0.08, then the driving under influence kicks in and you're arrested at that point of driving under influence. And then the juvenile petition kicks in anyway, and you'll be brought back to the barracks and processed as if you were over the age, but you would at that point, you would call in an adult who would witness the processing, and the juvenile would have opportunity to speak to the adult for some time prior to the processing and things. So different things play there, but once you hit 0.08, it's 1201 kicks in.
You may not know the answer to the question. When did that 0.16, if you blew 0.16 and if you got picked up again at 0.02, When did that go into? I've never heard that one
Yeah.
before.
If I remember right, it might have been around 2014, 2015, maybe. I don't know off the top of my head, but I believe it was around 2014-ish.
What if it was, say somebody blew 161718, whatever, before that date? That would still apply?
No, that was, yeah, it's your second or subsequent DUI with a .16 or greater from
Oh, second.
it's your second conviction.
Oh, okay.
Conviction. So you have to be charged and convicted of your second violation that was greater than .16. And then your third, you could be pulled over again after that conviction. And if you blow an O2, you could be charged with DUI.
I thought you said the first one at once.
No, it has to be number 2 or greater or more.
So I guess you may have answered my question, but I didn't hear it. So what happens to somebody before that date?
I believe there's a date range for that from this date forward. But don't quote me on that. I'll have to check.
So if somebody blew the 16 before that date, that wouldn't apply to them.
I believe so, but I can't.
That's okay.
Ken and Ian.
Probably not the right witness, but I was just gonna go on that. Didn't we change that in like year 21 or something during COVID at the last? It was one of this sticking.
He was saying like 2016.
If I remember right, it was around that timeframe.
It seems like there was something that was in there during that time period. Where it was, I think we were dealing with expungements. I don't think it was sealing then. I think it was where the first one would disappear or something because of the cannabis going in or something like that. Maybe Marshall can help me out, although he just shook his head no.
Well, we'll get to ask Marshall that when he gets up there.
He just shook his head no.
Well, ask him that question so you can verbalize it on the record. Ethan.
So right now, I just want to make sure I understand. So right now, if someone under the age of or above the age of 15 were to get pulled over and blow a .02 or above under 23 VSA 1216, they would have a civil violation which would result in a 6-month suspension of their license.
Are you asking or stating?
I guess I'm asking.
Okay. I just want to clarify.
Sorry. Well, I'm just trying to understand. I think it's I guess to Representative Arsenault's question about
Yes.
like trying to understand sort of the policy discussion here is that at the moment, there is a civil violation available for someone under the age of 21 if they blow above a .02.
Yes.
And should we move forward with the language as proposed in this bill, we would basically sort of redirect all of those cases to the YSAP program.
Yes.
And if they successfully completed that program, there would be no civil violation.
Yes.
And during the YSAP program, there would be no suspension of the license.
Yes.
Okay. That's all. Thank you.
It'd be the failure of the completion of that.
Yeah. So instead, and right now, is their license immediately suspended for 6 months, or do they have to have the civil violation? Do they have to be found? It's not guilty, right? They have to have
They're
adjudicated. Yeah.
correct. We don't seize their license. We have no notification to the Department of Motor Vehicles that they've had this O2. None of that takes place. What takes place is the issuing of the diversion paperwork and the issuing of the writing of the O2 ticket that currently stays with law enforcement. It doesn't even get issued to the offender.
So the only time, so when it would actually go like 12/16 actually would be imposed would be if they were eventually found guilty of a civil violation.
If they fail to complete diversion,
Yep.
then they get notified by diversion to Judiciary Bureau and
Yep.
say this violation occurred and they did not complete that. And then we get notified saying, okay, now you have to go issue that ticket.
Do they have to go to diversion, or is that something that the prosecutor makes the decision?
So that if they fail to comply by failing to go to diversion within that 15-day time frame, then they're in violation of that. And that's when we would be notified that, hey, they did not notify us.
Yep.
They didn't comply with it. And then now Judicial Bureau will be notified, and then the ticket would then be issued. Then they go through that suspension process.
Okay, that's really helpful.
So it's only failure to comply by the offender.
Yeah, okay, thank you.
So failure to comply, then you lose your license for 6 months?
I don't know the timeframe off the top.
What was the 6 months you were
For the first offense.
The
The
first,
first offense is 6 months.
yeah, with an opportunity for an interlock.
Speak my language.
The below thing to be able to drive.
In like ignition.
Okay. Okay, so, okay, thank you.
Can't remember how this works. You will. 15-year-old. Learner's permit. Can't suspend their license, but you can suspend their ability to operate on their learner's permit. What if there is an operator in the vehicle? Intoxicated, how would that all pan out?
So the rules for driving driving with a learner's permit is that you must have an unimpaired operator in your car. And then the impaired, I believe, the licensed impaired passenger would be the one that is in trouble for the permitted licensee. Off the top of my head, I believe that's what it is. I haven't come across that myself, so I've never had to issue
Well,
that.
you could have a learner's permit too on a 16-year-old or 17-year-old with the legal operator who's operating with you or
As impaired,
Yeah.
right? And then
they take the hit.
I would have to, let me research that and get back to the committee on that. Before I answer, I want to make sure I have that correct.
Figure out when we're train wreck with something.
Correct. Because there's some restrictions on that. And then when you get certain violations with your permit will prevent you from getting your license even when you're of age. So,
And you can't suspend one if it's prior to.
right, they won't have it.
So if you have an answer to that, if you can email it to Nate, he can distribute it.
Yes, sir.
That'd be great. Other questions for the lieutenant? Since I've lost a lot of my questions here, like, questions, thank you
Okay.
very much.
Yes, sir.
But we'll go to Meg next. We're gonna do a couple more, we're gonna do the rest of these witnesses, then we'll take a break before we take up another issue at 3:15, so. Thank you for being here.
Yeah, thanks for having me. Here sticks a little bit. Meg Rizzo, Executive Director of the Washington County Diversion Program. I've been with Diversion since 2018. And the age limit from 16 and up being eligible for YSASP is happened since my time. So I remember when youth under 16 could just be referred with the ticket, the underage possession ticket. So I've seen the confusion in the transition happen. And I think transitioning back would really alleviate a lot of inconsistency that's happening. I would say in my experience in Washington County, we have a variety of different experiences with law enforcement and their ability or receptiveness to our feedback about underage tickets being too young and needing to be cited into a juvenile petition. I think it would definitely just streamline the process. Having kids with multiple ages at underage drinking parties is pretty common, and making it so it's easier for everyone to access us at the same time would just make it a lot easier on everyone's end. I think we often get the confused parents calling in because, well, my neighbor said this is what they're doing and we haven't heard from anyone yet and we don't know what to expect. So we're often doing a lot of coaching through this is what to expect with the family court petition. It often ends up in our diversion program anyways and handled in the same manner. We do the same substance use screening with them, and often it's a low risk, low intervention response. By allowing them to also come through as the underage civil ticket, it opens them up to a program fee. Currently, family court cases, there is no fee. So it then gives them a similar financial consequence, which often at the ages for parents. But it allows for maybe more fees to be collected by programs serving this group. Additionally, I think the .02 tickets, in my experience, cause almost as much confusion as the under 16s. I printed out a ticket here. If anyone, it looks just like a speeding ticket. I can pass this around if people are interested. This youth wouldn't necessarily fall in the below .08 range, but this youth received an underage drinking, a .02 violation, and the DUI. So because they got this, the .02 violation, their license is actually suspended for longer than they would have for the DUI conviction, which is 90 days. So they're getting 6 months for the .02 ticket, which, as you can see, is $47. So if you are a parent or a confused youth with a stack of papers because you just got arrested and they handed you all this stuff, you see the $47 and think, like, I'll just pay this and take care of it because that feels like a really low hanging fruit. And there is nowhere on the ticket, on the back, on the front, that it outlines that once you pay this and you submit this to the Judicial Bureau, you should expect a 6-month license suspension and the completion of IDRP. And so we often get upset parents who are, calling us after their youth has completed the underage drinking portion, wondering why they're now getting paperwork from the DMV about a license suspension, which we then do investigating and find this .02 ticket and have to explain that that is separate. So I think allowing that to come to our office would really be beneficial. It would get them intervention at a more age-appropriate level, because I think a 16-year-old blowing a .04 versus an adult with a much higher BAC going through this impaired driving class, the needs are different in the education, like the ability to absorb it is different. So providing a more one-on-one approach or finding a more age-appropriate education and screening tool would really be beneficial for those youth that fall into that group.
I'm sure you can't answer this, but why isn't it on the front page of that, right where the $47 is, or above it? Like, you pay the $47, you're still going to lose your license for 6 months.
I wish it was. It would make things a lot easier for our office and our staff if it was clearly outlined. Just because it's not, it creates a lot of confusion and frustration on everyone's end.
So I probably missed this. How long has that form been like that, which is very misleading? I'd love a copy of that. I know what a speeding ticket looks like.
Yeah, sure.
Yeah, you did. Okay. What? And you got into this committee?
So as long as I've worked with the program since 2018, this is what the .02 tickets have looked like that I've seen. So, and sometimes people lose them, or they, in the chaos of police being involved with a young person and parents, depending on the age, paperwork gets misplaced, it gets lost, and nothing outlines this.
Do we have any idea how many people are doing this? They don't even know they're doing it, basically, or maybe they are. And how many of them are stopped again, that adding to the court backlog, for lack of better words?
I don't have those numbers off the top of my head. I think Willa maybe has more access to all those numbers and cases coming through. But I would imagine there's a decent amount. I think we have at least a couple each year, anecdotally, that end up with a .02, the underage, the DUI, and the underage drinking ticket.
But for the most part, they paid the $47, and then the parents or whoever is still notified that, no, you're not done unless you complete your diversion or whatever it's called, you're going to lose your license for 6 months. That is crystal clear.
So the .02 tickets are not diversion eligible right now. They haven't been. So the plan, it would be to add them so that it would be more clear. right now, you don't have, if you just received an underage drinking ticket, no .02 ticket. So if you are 16 at a party, get an underage alcohol possession ticket, your license is not suspended unless you do not complete diversion. If you don't complete diversion successfully, we notify the Judicial Bureau, the police department, and then the license is suspended for the 30 days plus a $300 fine. It's also my understanding, even people who only have a learner's permit, they can still suspend the learner's permit. So if you were set to take your driving test the next week, you are not eligible to take that driving test. And there's also now a reinstatement fee, which is $96. In addition to the cost of the test, the permit, and now the ticket you've received for not engaging in diversion.
So regardless, the taxpayer is still responsible for paying a lot of extra money for the individual that made the mistake. It's costing a lot more administration fees, blah, 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 all that stuff.
Possibly, there is definitely a lot more paperwork if it is not handled through diversion, I would assume, just because of all the different filings that are required.
Thank you.
So the .02 ticket that doesn't spell out the consequences. If this bill goes through H-105, the referral is going to be automatic, and that's not as big of an issue anymore? Or is it still a big issue that they're getting a ticket and don't know that?
So I think each law enforcement agency does it differently. I think even each law enforcement officer does it differently. I've started to recognize the patterns. But currently, not every youth that gets pulled over and is an impaired driver gets the .02 ticket. Some just get the alcohol possession or consumption. Some get the DUI petition, and then some get all three. So I think the part where we're now making officers choose what option they're going to pick also will really help. If there's only one ticket or one matter that we're trying to address versus three separate ones, I think it will make it a lot easier for everyone involved.
And so I want to make sure, though, that I understand this, that an individual, a 16-year-old, 15-year-old now, or we'll say 16-year-old, can get pulled over and has .02, does a breathalyzer. They can still get this ticket as well as being sent to the YASI program. I thought I understood that this now would be automatic referral to the YASI program.
Yes. So this, if this goes through, the intention would be that this .02 violation would be an automatic referral. Currently, it is not.
Right.
The underage drinking portion is,
Right.
but the .02 is not. So this would make it so they would come to our program, we'd screen them, connect them to services, and then there wouldn't be the automatic 6-month license
Right.
suspension.
They're not gonna be given a ticket, pay this $47 and you're gonna lose.
Right,
6 months.
exactly.
Yeah, that's so,
Yes.
so I'm less concerned of the lack of that warning on the .02 ticket, if that's not going to be relevant if 105 passes.
Right.
My understanding.
Yes, it would make it less likely that a youth would, or a family member would just pay it, and the suspension would go into place without notification of what it all means beforehand.
Okay, great. So is that, I just wanted to ask the lieutenant again if my understanding was right as well.
That they would be,
Getting confirmation that this, if this passes, they're not going to get this .02 and this pay $47 and you're going to lose your license for 6 months. It's going to go to the program.
it will be written, but it's not gonna go anywhere. It's gonna stay the same way. It's gonna stay at the local barracks, like it
Right,
does
as you
now.
had said.
It's not gonna be issued to the offender. The only time that comes into play is upon non-compliance to the program.
Okay, I just wanted to confirm that.
Yes, it'll still
That's
be
what I
written, but it
understand.
still stays with us, but it does not get issued.
Okay, great. Well, that sounds good. So, any other questions from me? Thank you for.
I think I have one, but I think it. So unless you're writing a DUI or an impaired, you're using a DMT, you can do a PBT on these.
Could you tell us what those acronyms are for us?
The automatic stir testing equipment or the Personal roadside testing machine.
Correct. And it states that in the statute, as long as a law enforcement officer is requesting it with an authorized preliminary breath test or a PBT, that's a roadside breathalyzer, that it's used many different things, but there's a tremendous list that I had just got updated by the Commissioner of Public Safety 2 years ago that everyone's using the same PBT. But as long as they're requesting that sample roadside, a refusal to submit would be an inference of guilty. Or if you blow numbers, then you're in violation of it. And there's been some folks that have blown numbers and they're a 0.17, and they don't meet that criteria.
Right.
They fall under the O2 type thing. So there's, but yes, the handheld PBT, non-evidentiary, evidentiary would be the data master back at the barracks, roadside, field side, stream side, it's the handheld PBT. Non-evidentiary.
So you can do 10 of those on scene and not have to go back to the office.
Correct. It's just, you have, carry around, I have a bag in my car still from when I was on the road a lot, and there's 100 breath tubes in there, because you change it per person. Breath tube, take the tube out, put the new one in, you can do that all day.
So the civil ticket can be based just on that roadside test, the PBT. The 0.02 ticket.
Yes,
To
sir.
confirm, just to, yeah.
It's a special provision,
Identify yourself for the record real quick and then.
Marshall from the Inspector General's office. There's a special provision in Title 23 that says that when you're dealing with the underage drinking or .02s, because it's not the charging as a crime, that the PBT becomes admissible, even though it's inadmissible if you're charging.
Right. Oh, perfect. All right, great. Thanks. Any other questions for me? I'm sorry, we're keeping you there.
That's okay.
Thank you very much. That was very helpful testimony. Thank you. So I'll go to Kelly next, please. And thank you for being here, Kelly.
Yeah, thank you for having me. Right, I am. Nice to be here. I've done this before, so I'm.
Oh, okay. So just identify yourself for the record and proceed with your testimony.
Great. I'm going to mostly read, though I took so many side notes, I'm sure I'm going to get derailed. So my name is Kelly Aarons. I'm the Youth Restorative Programs Manager at the Burlington Community Justice Center. I have been in the restorative justice field since 2009, and at the Burlington Community Justice Center since 2015. And in my current role, I sort of oversee and support all programming related to youth for civil, pre-charge, diversion, and probation services. I'm here to share about my experience with the YSS program. And don't you love how confusing it is? The court diversion is the name, the big umbrella term, but then the diversion program. So I saw that kind of getting mixed up. But the YSS program, under the court diversion services that we have been providing for Chittenden County since 2019, we, in FY24, for instance, just kind of give you a sense of the scope or experience that I'm coming to this conversation with. In FY24, we received 269 referrals, which is pretty consistent year to year.
And what was the age groups or the ages approximately?
For the YSS program specifically, it's 16 to 20.
Yeah, but as far as what you had of the 269, was there?
Yep, that's 269
for that age?
For just YSAS referrals. So these underage alcohol, cannabis, or buprenorphine session, but you get to see one. And instead of, I think, plainly describing the program, just to kind of, which you've heard a little bit already, just share a couple of quotes that our staff have recently gotten. The program is helpful. I learned new things about the risks of alcohol. I didn't feel judged. It was very impactful on showing me how my actions can hinder others and how I continue to grow as a person. Someone even said they were excited to have a substance use assessment, which is unheard of. And then, but I'm mostly here to discuss the challenges youth, families, and staff face in the current system and advocate for changes that would improve how we address substance misuse among youth. So I'm going to first just focus on possession by youth younger than 16, so 15 and under. I've seen numerous instances where law enforcement, for various reasons, issue YSAS tickets to youth regardless of age, where the ticket either turns into a delayed court citation or is dismissed altogether because of the administrative burden. or just all the different steps that are required on law enforcement. And then, which means nothing happens at all, nothing. Often youth see grade peers with similar situations or in the exact same situations like have already been described, where where their peers are receiving tickets and they're receiving citations to appear in court. And that at that time of incident, that does very little to support a youth accountability process, their sense of fairness of the legal system. When they feel aggrieved by the system, they're going to mostly center accountability there instead of deepening reflection. So we already kind of have an uphill battle when they're like, the system has done us wrong, and instead of us being able to, it just takes a little bit more work to get there. I want to share an example of a situation that really exemplifies all the challenges of what currently exists with the 16-year-olds needing that delinquency petition filed. So I've changed dates just to kind of and other identifying information. So in August, we were asked by another county to complete a YAZI, which is that screen that every juvenile is offered when they are cited to appear in court. So I know all the YAZI and YSAS. So we were asked by another county to complete a YAZI for a youth who lived in our area. So that was in August. When we received the affidavit, we read through the affidavit, we discovered that this was for an incident in May, 3 months prior. At that time, that youth was mistakenly referred to the YSAS program. And I think the lieutenant spoke to this as well, it's very understandable for law enforcement in the heat of a situation when they have so many youth of a party that they may be breaking up, where they're focused on safety, right? Folks are getting in their cars, they're running away. They are not going to remember, or it's just going to be too much to kind of identify that distinction between, okay, who's under 15 and doing all the math as it relates to it. This particular youth took responsibility by immediately reaching out to their local diversion office. So they were ready, they owned it. I was drinking, like, what can I do? And they were told, right, based on statute, that they were ineligible for the YSAS program, which is true. However, 2 months later, in July, so this is now, X number of months after this rape incident happened in May. And so in July, the police department contacts the parent and says, can you please drive to our office in this other county to receive your child's court citation? They need to appear in court in 2 months in September for this underage drinking, which again is correct. This is all correct. And by correct, I mean, this is the design of the system currently. This led to confusion and frustration, especially since a couple of other youth, and I found this out later in the process, at the same party, who were also under 16 and cited to appear by court, right? Parents were asked to come in. The parents that were loudest or raised enough concerns, the officer just dismissed those tickets. So then already within this, there's now disparities between who's getting any level of accountability or support. So ultimately, this youth came to our office for the YAZI, scored low risk, and was then referred to diversion, where they completed their process successfully. While this particular case was extreme in regard to the number of issues, it does reflect common struggles and confusion that youth, family, and staff, and I sort of mean that for diversion, and police officers, due to current statute and system inefficiencies. I think that expanding the YSAS program to include youth under 16 would streamline this whole process. Also, it would be a better use of staff in police time in so many ways to be able to focus, I think, on, some very significant work and time is money and cost, all of us. So youth could engage in this new, if you all were to expand the YSAS program to include under 16-year-olds, youth could engage with one staff member early on, build a rapport. They could be screened for substance use and participate in restorative interventions more quickly. This would provide clarity for law enforcement, eliminate unnecessary court involvement, and support timely accountability in cases that already require pretty nuanced responses on our part. Also, if there is a non-engagement or non-completion for that under 16-year-old, there is that backup consequence of the delinquency petition being filed. And if successfully completed, then there's more alignment in terms of the confidentiality of our process, where, because the YSAS program is, I don't know if that is the like strictly confidential kind of comparison, but that name gets removed from the incident report altogether. That's the, I think, really wonderful thing about the YSAS program is these first-time offenses, these low-level youth engaging in what some would say is sometimes developmentally appropriate behavior, that this is not on their record forever. Whereas even if they're, for these under 16-year-olds that do complete, like, yes, juvenile proceedings are confidential, but it's less confidential than a successful completion via YSAS. Yes, yeah. Well, I'll pause there because then the shift is to point out two.
Yeah, so this is, I guess it's more of the 0.02 that I'm gonna have this question about probably, because it's a second and subsequent. And my question would be, twofold is what is success? Because you talked about being successful in the program. And when there is success, there presumably is some record somewhere, since we have a separate penalty for second and subsequent. If you could address those. I mean, the first one's probably a broader question.
I don't think I'm the best one to answer that because of, well, my understanding is it does depend on law enforcement agency, what I hear as a response to how records are kept and removed. And
so it's a law enforcement agency that would know that it was a second or subsequent, not necessarily the diversion program.
Exactly. Well, we would know if it was in a certain time period because we have our own record, like shared record keeping across the state.
Okay.
In diversion programs. But I can't answer I don't know the mechanics behind the scenes on the law enforcement end of how they're showing the offense. But so when somebody completes the YSAS program currently, right, these are for 16 to 20-year-olds, when we sort of similar to how the ticket that Meg showed, where the personal identifying information is voided out at the top of that ticket, that the Judicial Bureau in the state is only sort of, there is the incident that exists, but that the young person's name associated with that incident is not shown, not visible. But I'm not sure if others have better clarity around some of that.
Yeah.
Yeah, so that's on, if you look on page 11, under 12, subsection H, that's what talks about those kind of segregated DMV records at the top of page 12 can be accessed by a law enforcement officer to determine whether the person is previously violated.
Okay, thank you. Thank you. I forgot that, even though you just went over it, not an hour and a half ago. So can you, the first question as far as just, what does success mean in the program?
Currently with the YSAS program, yeah, I mean, it's court diversion, the practice that we use is really based on the R&R principle, which is risk, needs, responsivity. So, right, we're looking at the risk that youth may have to reoffend. What are the needs that are present? If there was impact there, right? Sometimes that impact is on self. So it may be doing some intentional repair with oneself. Sometimes that impact is on your immediate family. And sometimes there may have been like a broader community impact. Let's say, here's a situation where there's a party, right? 10 people at a house. The parents knew that their kid and their friends were gathering in the basement, but pretty off, not super involved. Police get called in for a noise violation from a neighbor and then come in to discover that those young people have been drinking. Let's say there's a youth there that has known that parent for a long time, and they there's that breach of trust between that young person and their friend's parent. And so they may want to utilize this conversation, right, where we've already screened them for substance use and we know that they're low risk, but then they're still feeling like they want to make some kind of repair with that parent. It may write a letter or a card, or they might bake their friend's parents something. So while that's sort of an unusual example in the sense of the details, but it is an example that we've had multiple times. I think the main idea on success is like we're first sort of screening around substance misuse. If there's low impact, our involvement is meant to be explicitly brief, like not like, it's the community. The way that we often try to frame it with young people is, this is a community checking in to say, how are you doing over there? What's going on? What do you need? How can we get you connected to what you need? And they're really the driver about where that goes, or the parent, if this is somebody who's under 18. And obviously that adds like a whole other layer depending on the parent's perspective on substance use at all for teens. And then again, the more that there is that impact or ripple effects, even for something as seemingly low level as YSAS, this YSAS program allows for the space and opportunity to dig into that a little bit. Again, what is the impact on self? What is the impact on others? And how are you moving forward? One of the questions in the screens is, or multiple questions on the screen itself, focus not just on the quantity and amount young people are consuming within a specific period of time, but also there's impact and then forward thinking goals around where do you want to go from here and how are we supporting that youth to align their self and their values like with their actions. So that's a very broad response. Like, what does success mean in this?
No, it's helpful to understand what happens in there. So I really appreciate that.
Yeah. And more often than not, it is all just it's a low level brief intervention because a lot of these situations are not. But then this young person is like, thank you. I'm like looking forward to my substance use assessment because this is also the community, right? Accountability can also mean care, right? Like I care that you, I see you having a hard time over there. What do you need? And folks like young people in particular can feel validated around, like, yes, I'm in trouble. And like, I see that I maybe should be working on something.
Andrew.
I was just kind of going to say a little bit of what you just said or asked that in terms of success and what success looks like. Everything I'm hearing sounds like this is a much more, how would I say, a holistic version of success as well versus paying a fine.
Well, yes. And so, because there's the under 16, which are currently, and Meg, I think, alluded to this in her testimony around these 15-year-olds and under who are currently being sent to family court are generally coming to us anyways, just via our diversion program. And so we're doing the work regardless. We're just doing it way more slowly and a lot more, spending way more time on phone calls, often not very happy phone calls. And then there's the component too around, right, some officers work nights. And so for us to be able to actually get all the paperwork or get in contact with the officer to explain the situation, and just can fold it right back in for those under 16-year-old. For the .02 tickets is slightly, I'll shift.
Let's go to .02 tickets. Thank you.
So I also support the proposed expansion of YSAF to include .02 civil DUI violations. Drinking and driving is a serious issue, and I think it's really important to educate young people about the consequences earlier on and not wait till they blow a .08, right? Like sort of that, just even that moment of .02 being a kind of a real face of reality. I'm just speaking for myself. I do have reservations that some of these changes, there wouldn't be any kind of license suspension, but I do think there is still an opportunity here to strike a balance between support and accountability that feels very in alignment with the work that we do. So one key issue currently with how the .02 civil DUI processes is the confusion surrounding these tickets. Some of this has been spoken to already, and I'm going to repeat it because it is confusing. It's a crazy amount of my brain is taken up with information about this program. When youth receive a YSAS and a .02 DUI ticket, that civil DUI ticket, they're often told by officers they will not face suspension. They're like, go to diversion. This is here's this diversion, because sometimes officers don't know that the .02 ticket, there's a 6-month suspension incurred from that ticket. And so they come through YSAS, they think they're done, and then they're like, what is happening right now? And then we have to go through it all over again. Sometimes the ticket will just say .02 in the description. What does that even mean? So leaving the youth unaware of what kind of tickets, it's $47 fine. And again, coming with that 6-month suspension. Yes, even if there's like a really brief description in that ticket and the statute is down there at the bottom, it's not the common sort of the average person, be them young or old, don't necessarily know how to navigate looking up Vermont statute and reading through what does this even mean. It was really interesting to just kind of watch the first part of all of this earlier too. So they may pay the fine, not knowing. I think Meg explained it really well in regards to it's low hanging fruit. Oh, there's only this $47 ticket we have to pay. And then they get that letter around the suspension IDRP requirement. And then in some cases, like was also shared, they might face the underage drinking ticket. So they get the YSAS referral, the criminal DUI because they blew over .08 and they incur that .02 ticket. I would also say that additionally, the legal system sends mixed messages. I have found, and this is kind of reflecting back conversations we've had with youth, when comparing the penalties for a .02 DUI and a criminal DUI. So while both the criminal DUI, which is blowing over .08, and the civil DUI, which is blowing over .02 for these under 21-year-olds, the .02 tickets leads to a 6-month suspension, whereas a criminal DUI leads to a 3-month suspension unless you do the refusal to blow, and then it's a 6-month suspension. This difference is confusing. It angers young people who have asked us multiple times, so you're telling me I could have had more that night and gotten behind a vehicle and I would have a shorter suspension? And the answer is yes, they would. Like, there are obviously other penalties that come with a criminal DUI, but that is the truth of it. That frustration really distracts from the real work that I feel like our staff try to do around substance use and supporting youth to deepen their understanding of impact and safety. And it creates unnecessary stress for youth and their families who struggle. So right now there's a 6-month suspension and now they have to figure out transportation for getting their kids to school because there's not public transportation infrastructure, right? Like everyone is very reliant on their vehicles. And so school, work, all of that is really disruptive. Expanding the YSAS program to include .02 tickets would allow diversion programs and the YSAS program specifically to address these issues more immediately, incorporating the substance use decision-making process into a restorative, holistic response that centers their safety and community safety specifically. For instance, at our office, we offer a youth safe driver workshop for any driving related offense, and it has been effective with guiding you through the restorative steps. Potentially something similar to this could be implemented across all YSAS providers for these .02 tickets in lieu of IDRP. And I do think that essentially this expansion would enable us to provide consistent support, including, again, the substance use screening and educational opportunities instead of just purely a punitive approach and somewhat arbitrary. So those are my main points. There's further questions.
Ian and then Karen.
Okay.
Karen, then Ian.
I just want to thank you for being here. So in my job outside of the legislature, I work at the Essex Community Justice Center, and I just know we've had conversations about, I think an officer with good intention sent us a pre-charge referral for a 15-year-old, something for drinking, and because wanting to have that immediate impact that pre-charge and diversion can do. But we don't have any at our stores, don't have any of the resources to do a screening or anything like that. So it's just nice to see you here, you know, unfortunately years later, when we're trying to address that. So just appreciation for the work that you're doing.
Yeah, right back at.
Thank you, Ian.
Thank you very much for your testimony. I think my question is to sort of get at your hesitation a little bit on the not having any suspension. So could you speak a little bit to your views on youth accountability and having some sort of suspension as a consequence to a 0.02 or above penalty?
Yes. I think it is okay that there are some consequences to our actions. I think it is okay that we model and create systems for young people that still there's like a line. There's a line. And our response as adults and our response as a system should match that. And in a situation where somebody is getting behind the wheel, when there are lots of other alternative choices that you can make, even after having one drink as a young person, knowing that you're not even drinking legally, right? I think it's okay that there is a component to adult and system responses that isn't explicitly restorative. I think it's probably the simplest way to put that.
Appreciate it. Thank you.
So do we have to consider having some sort of suspension even in the, if they're going through the program and just not successful? Is that the idea?
Like an automatic suspension for a certain amount of time?
Or I'm just sort of looking. or like there could be upon completion of their YSAS process for the 0.02 ticket, then the BJB and the police department are notified that the suspension ends. So it could be some, again, that's what I mean in terms of that balance of like accountability, right? Like the suspension remains in effect, and let's be reasonable here. And at the very least, don't have the 0.02 ticket be a 6-month suspension and have your criminal DUI be a 0.08, 3-month suspension at the very least.
So do you know how, or Willa or anybody, how often you see second and subsequents?
I mean, Willa might have statewide numbers. In our office, are you talking about 0.02 specifically or any underage? That I cannot answer.
Because I guess I could see having some sort of automatic suspension perhaps for the second or subsequent person, an initial one chance. But if you mess up again, you can still go through the program, but facing at least some sort of additional consequence because apparently they didn't learn their lesson.
Yeah.
That's something to consider. Maybe we'll have Will or others comment on that as well. And Marshall, who will be up next. So, but yeah, that really depends. I'm just kind of curious on if that kind of data exists. Does that kind of data exist that you know of, Will?
If anyone had that data, it would be the.
Okay.
But we don't know. We currently don't receive 0.02, so we don't have anything.
Right.
And I think reoffense for that particular offense would be tricky to parse out the reasoning because, right, kind of as of now, if there was a low reoffense, you could associate that with a high suspension penalty. Whereas in the future, if it were to expand 0.02 to be eligible for the YSAS program, you could say the low reoffense is because we've had a success in our restorative process. So I think that's something.
Okay.
What are does anybody know the suspensions for junior operators right now, currently? What it is?
For an alcohol offense.
No, for any moving violation. Well, I think the point isn't applicable to the junior operators, is it?
Junior operator for a point violation, their suspension. Any single violation of 3 points or more is a suspension. And then any
Is it a 10-day suspension?
to 10-day suspension for one violation of 3 points or more conviction. And then one conviction with accumulation of 6 points in a time frame. I don't know off the top of my head, resulting in a 10-day suspension or less.
So it's 3 points for 10 days versus 10 points for 10 days, 2 years.
Correct. So any one violation, and for example, if you're speeding, if you're doing 50 and a 25 on, and a 35 on, and a skunk hollow and Jericho, like you're gonna lose your license for 10 days.
Yeah.
Because it's such an egregious offense.
Right.
If you're doing 80 and a 65 on the interstate, it's a 2-point violation. You're not gonna lose your license for that violation.
Lots of options.
Can you hold that question? Because we need to give Marshall 10 minutes, and if you need more time afterwards, we'll have you come back in again. But we need a little break before we have Justice Carroll and some other folks are coming in for 3:15. So I want to make sure we have a little bit of time, but also a little time to Marshall. Is that all right?
Yeah.
Yeah, as far as good question. Okay, so Marshall, thank you very much.
Yeah, thanks.
Oh, one other, if you can, I noticed you had notes on your written testimony. If you want to update your written testimony, could you send it to Nate for posting?
Sure.
If that's possible, or whatever you had as written testimony.
Yes.
Okay, and I missed Meg, and I was going to ask Meg to give us that ticket, but we can. Okay, so if you can get that to me as well. So Marshall, if you join us, and I apologize that we only have 10 minutes, but I don't know how much you have to say today, and we can have you back, of course.
All right. Thank you very much. Marco Paul from the Office of Defender General. We support this bill. I think, as has been said a number of times, the dealing with underage drinking tickets, the .02 tickets, is incredibly confusing. It's actually the thing that I get the most kind of colleague-to-colleague questions about. The most recent one was from a judge in Connecticut who was unable to understand our. Thank you very much. I was looking for that. I don't like this water bottle. This is more like spare water bottle.
We didn't fill it for you.
It's fine. So a judge in Connecticut who was looking at our laws because her son had picked up is a UVM student and picked up an underage drinking ticket. And she could not understand our underage drinking laws, and she's a judge. And I've answered these questions for numerous public defenders in Vermont who you think they practice this law, they would understand it, but when their own children get picked up for underage drinking, even they have a hard time sort of parsing out what the laws are. So from our perspective, this is really necessary because honestly, in this area of law, there is so much mixed up and frankly, just incorrect practice. And this clarifies it in a way that is tremendous, makes it 200% easier to read and understand than what was there before. So to begin with, we like it just because of that, just because of the simplicity. As far as expanding from age 16 down to age 10, we agree that it's a smart thing to expand below age 16. We think going all the way down to 10 is not quite appropriate. YSASP is a great program, works really well with the people it works well with. We certainly have not seen, I think when you're talking about somebody who's age 10 or 11, YSASP might be appropriate if it's an underage drinking situation. But if you have somebody who's 10 or 11 who is drinking and driving a car on a highway, that probably requires more than just a YSASP intervention. That really is something that's probably more of a sign of a lack of supervision, abuse, neglect, or a child beyond the control of their parents, and probably should be dealt through the child welfare system, which really wraps in the family, because at that point, if you got a 10 or 11-year-old driving while drinking on a highway, you've got a family problem.
I don't think
More than you have a.
this doesn't prevent any of that follow-up.
Yeah, what we would suggest is we would suggest that the minimum age should be, that 10 is just too young, and that between 10 and 12, that's really like, we should be addressing that in the reports as a family problem. And frankly, that makes a lot of sense. One of the biggest drivers of adult drunk driving is parental drunk driving. If you're a child and if you grew up riding in the car while with adults who were drunk, whether they were your parents or anybody else, you are vastly more likely to grow up to be an adult who then goes on to drive drunk. And so that's part of the reason we really love the YSAS program, like the way that this bill sort of integrates YSAS into all statutes that address underage drinking, is because drinking underage, that's really a point of intervention that's really important because it has such serious consequences in the future. And we want to make the sort of barriers to that process as minimal as possible, make the process as accessible as possible, and make it something that people aren't resistant to participating in. And we think that this really accomplishes that. So I think that's all my notes. I'm happy to answer any questions, but we support this.
What about if we had a minimum suspension, like a 10-day suspension to be similar to what we have for like 3 points or more? I mean, it seems like if you were driving after drinking, that seems to be pretty darn serious. And what do you think of the concept, either for second or subsequent, having a suspension at the same time, or a very short one for the first?
So just, I have a clear position on this, but it's going to sound confused. And so give me a minute to get all the way through it, and then you can criticize, which is, I think suspensions serve a very valuable purpose, but I hate using suspensions as punishment, because essentially you're punishing somebody by saying, we're going to take away your ability to go to work, you're going to take away your ability to go to school. That doesn't mean there's never a need for a suspension. To me, suspensions are about incapacitation. They're about taking people who are demonstrating that they are in a place of dangerousness on the road and getting them off of the road so that they can't hurt other people. That should be the purpose of it. If we're imposing them in order to punish, or in order to make somebody, feel like they have some skin in the game or whatever, we should be using some other mechanism that doesn't cause them to lose a job, cause them to miss school, cause them to miss, opportunities that we really want people to be taking advantage of and developing. So I'm not opposed to the idea of a suspension, but in my mind, suspensions should be tied directly to the danger that's posed. And so, a 10-day suspension, I wouldn't necessarily be opposed to that. I do wonder, is that actually serving a purpose? Like, do we see that, like, when we catch somebody underage drinking and driving, is that indicative that they're in some sort of acute window of dangerous behavior that can be sort of averted with a 10-day suspension? And if so, great, that would be a solution. And if not, if it's more just to give them sort of a punishment, I would suggest something else. I'm not sure exactly what, but something that's not going to be tied to their ability to keep a job, their ability to go to school, things like that.
I guess it would seem, well, let me ask, would somebody who's getting a second or subsequent, would the rationale be a little closer to, hey, this person hasn't learned their lesson, maybe they shouldn't be driving, going to that safety concern as opposed to punishment concern?
Absolutely. I'd still just want to keep in place the ability for them to regain their license in some way or another, or their ability to drive, I should say, whether it's through an ignition interlock, some way, because when you think about it, it's possible that somebody, and I'm not suggesting that the suspension is not appropriate given the dangerousness of the conduct, but I'm just saying that when you're looking at someone who might get a suspension from age 16 to age 21, That's a very possible suspension under these laws. You're really removing somebody from there. That's a really important developmental phase in terms of integration into society, moving from secondary education to some other form of training or post-secondary education, getting into the job world and developing a career type of job. Interfering with that is a really tough thing at that age. If you take someone's license away from age 16 to 21, you're really crippling their ability to develop some of the competencies and skills and experiences that we want them to have to go on to be really productive people as adults. So it's a balance. From my perspective, it should be very much tied to safety, not to punishment.
Yeah, we certainly have tried to have moved that direction with DLS and so on. Any other questions that can be answered in 1 minute or less? All right, thanks a lot, Marshall. I really appreciate your testimony on this. So, all right, so we will break until 1:15, and we have, like I said, Justice Carroll here along with some other witnesses as well, talking about access to justice and a dollar request.